I just want to make clear, Wendy, that I'm happy to answer questions that are, in my mind, clear enough to answer, but it should be made clear that these answers to these questions are for information basis only, and if people are intending to take any legal action, that they should consult a lawyer. So that's clear because things change with the facts. And so if there's any facts in the questions that I'm not made aware of, proper legal advice can't be given. So these are basic informational questions and basic informational answers based on the question.
Thank you for joining us today, Rocco.
Thank you for having me.
So this question today comes from Lisa. How would the best way for an employee to refuse a weekly rapid test imposed by an employer because the employer hasn't taken the actual shot?
I'm sorry that the employer has not taken the actual shot. I missed that question.
Yeah, the employer has not taken the vaccine. So what would be the best way for an employee to refuse the rapid tests that are being posed by their employer?
Well, any test is a medical procedure. You're protected by provincial law and the charter against any medical treatment or procedure without your informed voluntary consent. Above and beyond that, the Non-Genetic Discrimination Act of 2017 under Section 3 makes it a criminal offense for anyone to insist on an DNA or NRA test to determine whether or not you're susceptible to have a transmittable disease. That offense is punishable by a fine and up to 5 years of prison time. So it is a criminal offense for anyone to insist on such a test.
So would you recommend that they serve their employer with a notice of liability or something?
Yes, and there's different notices out there. For instance, Action for Canada on their website has notices of liability, and they can inform their employer this is a criminal offense, and I'm not required to take any testing without my consent.
So they would have a chance later on if they're fired in order to take their employer to court with regards to wrongful dismissal, if that's the case?
Right, they can take the employer to court for wrongful dismissal, and they can also go to a JP to swear a criminal charge under that act.
Okay, perfect. Thank you very much.
You're welcome.
We are Canadians. We are free